Hearing the appeal, Malik Momin against Beverly Point Resort Estates Limited.
Good morning, Ms Hepburn, and good afternoon to counsel here.
Good morning, my lord.
Please begin your submission. Thank you.
May it please you, my lords. My name is Candace Hepburn, appearing on behalf of the appellant, Beverly Point Resort Estates Limited. My learned friends, Mr. Richard Wilson, QC, and Ms. Christina Galanis, appears on behalf of the respondent, Mr. Malik Momin. My lords, with your permission, as I'm appearing via video link, may I have permission to sit while addressing the court?
Of course.
I'm much obliged.
You can take it, Ms Hepburn, that we have read the judgments below, we have read the statement of facts and issues, and we have read the parties' written cases, so you don't need to introduce the facts in any detail. We have that, I hope, under our belt. Thank you very much.
I'm much obliged, my lord. Lords, we are before you today on an appeal of the decision of the Court of Appeal from the Commonwealth of the Bahamas. That was made on the 1st of May 2019. And by this appeal, my lords, the appellant is seeking for this court to set aside the judgment of the Court of Appeal for reasons which I shall further elaborate on. My lords, during the time which has been allotted to me, I shall endeavor my best to address both the points in limine raised by the respondent, as well as set out the reasonings as to why this honorable court should set aside the decision of the Court of Appeal and uphold the ruling held in the Supreme Court of the Commonwealth of the Bahamas. My lords, if I may refer you to the written case of the appellant, which can be found at page MS 961, the electronic full bundle.
I'm so
I
sorry,
wish to
961.
I'm afraid I haven't quite got there yet.
Yes.
Thank you.
No, Lady Arden's just getting into her computer. If you just pause a second so that she can find the document. 961. Yes.
Thank you. Thank you very much.
I'm much obliged. Lords, I would first wish to address the points in limine raised by the respondent. And my lords, just for clarification, the respondent's initial objection was on the ground that the appellant had included a fifth ground of appeal without leave of the court. And in seeking to amicably settle the objection, the JCPC registry was advised on the 24th of May 2021 that the appellant was more than willing to forego the fifth ground of appeal and address the issue of interest and title under the first ground, as was done previously in the lower courts. My lords, as there is still an objection to this resolution, I wish to lay before you our arguments regarding interest and why it ought to be allowed to be argued before this honorable court under the first ground of appeal. My lords, firstly, we would wish to draw to the court's attention that the argument regarding the respondent's interest was first raised by the respondent's attorney at the very onset in the Supreme Court during their arguments. The respondent, via his attorney, stated to the court, and this would have been Ms. Galanis, she stated, "So, my lady, we say that when one considers the contract at page 5.11, it specifically said, the vendor shall retain rights and interests in the lot until all payments are completed in accordance with this agreement. So it is therefore clear, my lady, in this case, that no interest passed to the plaintiff upon executing the said agreement." My lord, just for record purposes, that was found in the transcripts, starting at line 24, page MS 58. Now, my lords, I will not go through each of the points in which the argument of interest was raised in the lower courts, but I do wish to draw to the court's attention Another instance where it was raised once again by the respondent in the Supreme Court. The respondent's attorney, Ms. Galanis, once again stated, "So we say, my lady, that the clause in and of itself, which gives the defendant or allows the defendant to retain the rights and interests in the lot until all payments are completed, it would distinguish it from the case indulted." I'm allowed once again, just for record purposes, that is found in the transcripts at page MS 59, starting at line 18. Now, my lords, I would have shown you the instances where the interest argument was raised in the Supreme Court. I wish to draw to the court's attention the points raised by the justices of the Court of Appeal. My lords, once again, after the respondent's attorney, Ms. Galanis, raised the issue of interest in the Court of Appeal, the Justice of Appeal, the Honorable Milton Evans, stated, "Why is that not any different from any normal court of what transpires in a property transaction, Ms. Galanis? Because as I understand it, and I am not a conveyancing expert, but as I understand it, when you enter into an agreement for sale, there are mutual rights. The person who puts his deposit receives an equitable interest in the property to the extent that you cannot take that property and sell it to anybody else or divest of it while that agreement is in place." Now, my lords, it is our humble submission that there can be no argument by the respondent that the issue regarding interest is a new point which cannot be addressed under ground one of this appeal. Notably, my lords, the sole reason that all of these issues were brought under ground one is due to the fact that in the Court of Appeal, the learned justices felt that grounds 2, 3, and 4 of the respondent's appeal were nothing more than submissions relative to ground 1. For that reason, my lords, you would note during the reading of and the history of this trial that there were numerous arguments and points raised under that particular ground pertaining to the correct interpretation of Section 62. However, my lords, when handling the appeal of this matter to the Privy Council, this approach, in our view, was contradictory to Practice Direction 6.3.1, which encourages brevity and a concise summary when presenting one's case. As the Respondents' Council was the one to raise the point regarding interest, rights, and title passing under ground one in the lower courts, it cannot be that the appellant herein is unable to address the court on this very same point. My lords, what is deemed a new point is certainly not issues that were raised, argued, and ruled on in the lower courts. And so on this basis, my lords, we say that the respondents to now put forward or even object to the interest argument being argued under ground one is disingenuous, as this is precisely what they had done in both the Supreme Court and the Court of Appeal. And my lords, the respondent at this time also alleged in its written case that the appellant is attempting, and this would be the second point in limine, my lords, that the appellant is attempting to insert a new ground with respect to referring to Section 4 of the Conveyancing and Law of Property Act. And my lords, we wish to once again express that this is certainly not the case. As found, and just for record purposes, my lord, this is found at page MS 164 at paragraph 63 of the electronic bundle. The appellant in its written case before the Court of Appeal stated, "We submit that if the appellant merely sought the correct interpretation of Section 62 and felt that an application was required, then he ought to have made an application pursuant to Section 4 of the Conveyancing and Law of Property Act." Now, my lord, I will not read out Section 4 of the Law Conveyancing and Law of Property Act, but that particular section deals with vendor-purchaser summons. And notably, my lords, the point regarding Section 4, which was raised by the appellant here in the Court of Appeal, it was only raised as a result of the respondent's sixth ground of appeal. My lord, in that ground, the respondent asserted that if the appellant was successful that costs should not have been awarded to our client because the respondent's attorney was under an obligation to approach the court on the proper interpretation of Section 62. My lords, we were merely pointing out to the Court of Appeal, in including that Section 4 reference, that the respondent's claim, which was commenced by writ of summons, was not for the proper interpretation of Section 62, but rather for the monies to be returned as they had already decided on its proper interpretation. And so to put forward an argument that if the appellant was successful in the Court of Appeal, they should not be awarded costs, we were submitting to the Court of Appeal at that time that it was disingenuous. And my lords, despite the respondent putting forward these two objections, we trust that having directed their lordships as well as the respondent to the relevant sections of the history of this case, that we be allowed to proceed with our arguments. My lord, that would be the appellant's submission regarding the points in limine raised by the respondent.
The sensible position, I think, to take at this stage is to allow you to advance these arguments de bene esse, i.e. provisionally, and we'll make the decision later. But we will hear you on those arguments in the course of your submissions today. Thank you.
I'm much obliged, my lord. My lord, if I may now then go to the first ground of my appeal, which is once again found at the MS 965 of my written case. My lords would note that the first ground of appeal has been separated into 4 parts in an attempt to provide some form of concise summary of each section. My lord, under ground 1 of our appeal, we submit that the learned justices of appeal erred in their interpretation of Section 62 of the Planning and Subdivision Act 2010. Section 62, subsection 1 of the Planning and Subdivision Act states, any conveyance made after the act comes in effect regarding lots not granted prior subdivision approval shall be null and void. Now, my lords, you will note in the written case of the respondent, there is much emphasis given on Section 62, subsection 1, on how no conveyance can be issued after the fact, after the act, my apologies, has come into effect, and how the first and most fundamental rule of statutory construction is that a court must adopt and apply the plain meaning rule or literal rule of construction. And my lords, with this point, I wish to note that Section 62 does not end with Parliament making any conveyance null and void after the act comes into effect. In fact, Section 62, subsection 2 of the said act starts notwithstanding. And my lords, this word is pivotal because despite the respondent's claim in its written case that there is nothing in Section 62, subsection 2, that modifies, alters, or affects the provisions of Section 62, subsection 1. This is clearly incorrect. The word notwithstanding, my lords, established a precedence over Section 62, subsection 1. And its plain, clear, and unambiguous meaning shows that despite what was stated in subsection 1, regardless of what was said about conveyances being null and void, if a beneficial owner of a lot in a subdivision prior to the commencement of the act has agreed to convey land within a subdivision but failed to obtain approval, then such agreement to convey or conveyance shall not be null and void. And my lords, this is a point that we strongly wish to highlight to the court because Section 62, subsection 1 is speaking solely about conveyances made after the act. And because of that, my lords, when subsection 2 starts with the words notwithstanding, it is clear that Section 62, subsection 2 also has to deal with conveyances made after the act. And so, my lords, it is clear that what is being said is
Could I just
regarding...
clarify one point with you? You're putting a lot of emphasis on the word notwithstanding.
Yes, my lord.
You're in fact treating it as the equivalent of saying in subsection 1 that this subsection is subject to subsection 2. An alternative interpretation might be that it is clarification of the scope of subsection 1, namely saying that subsection 1 means what it says, but it doesn't affect certain things in subsection 2, namely that a prior agreement to convey which has been completed, or a prior conveyance which has been completed, isn't null and void. I think that's the alternative interpretation, but your position, as I understand it, is that notwithstanding is capable of bearing only one meaning. Is that right?
Well, my lords, our position is that if we were to use the plain and literal approach of what the word notwithstanding, if that is how we apply this to this particular statute, notwithstanding means despite and regardless, if we were to use the literal and plain approach, my lord. And so it is our submission that in this circumstance, when applying that plain and unambiguous approach, notwithstanding would mean despite and regardless of what was noted in subsection 1.
Thank you.
I'm much obliged, my lords. My lords, there is a clear understanding we submit from this legislation that there was an appreciation that there were ongoing sales transactions and agreements to convey, such as the case herein, which would have created conveyances after the act came into effect. And it is our submission that those conveyances, including that of the respondent, would be protected pursuant to section 62, subsection 2. My lords, it's submitted that in the plain and clear reading of this legislation alone, the proper interpretation can only be that section 62, subsection 2, allowed for conveyances after the act to be issued to persons, notwithstanding the provisions of subsection 1. And notably, my lords, we wish to provide further points, which would show that the only reasonable conclusion that can be arrived at is that the respondent herein is free to receive his conveyance without...
It's frozen.
I think Ms. Hepburn's connection is frozen.
My Lord, I am an agent for this council. I'm in touch with them on WhatsApp. They are retrying at the moment to reconnect to so I will update you as soon as hopefully she will appear, but if I have an update, I'll let you know.
Thank you very much. That's a good idea.
A brief update. I understand it's been rebooted courtside, as it were, and that we'll get you shortly.
Thank you.
Hopefully it should be turning at any moment now.
Thank you.
To adjourn. There's still coming from,
Yes. The court will adjourn. Ms. Hepburn, I'm sorry you had that difficulty. You were on the point of explaining to us why both the prior transactions and the conveyances which later flowed from those prior contracts were protected by Section 62(2).
Yes, my lord. And my lords, on that point, our submission is that the only reasonable conclusion would be that the respondent is free to receive his conveyance without subdivision approval. And my lords, I started at that point, I believe I may have stalled at that point.
Yes.
To bring to the court's attention that both the appellant and the respondent agree that the agreement for sale in this transaction is valid. This was the position in the Supreme Court, the Court of Appeal, and it was affirmed once again in the written case. The respondent, however, is claiming that despite the agreement for sale being valid, the conveyance which would flow from that agreement for sale would not be valid unless subdivision approval under the new act is received. Now, Lords, whilst we submitted that section 62 subsection 2 in our view has clearly shown this not to be the case.
I think Lady Arden would like to ask you a question.
I'm so sorry.
Oh,
I didn't want you to interrupt the flow of this important argument. But when you say that both sides agree that the agreement for sale was valid, could you be very specific about the point in time when you talk about the validity of the agreement? And so far as that agreement is concerned, do you mean at all times?
Yes, milady.
Right.
If I may refer you to the Supreme Court, and this was noted.
No, don't worry about the reference. I can find that.
No problem.
To be sure.
Yes, milady. Milady, in the Supreme Court, my learned friend Christina Galanis conveyed to the Honorable Justice Indra Charles that she agreed that the agreement for sale in its entirety is valid. That is not being challenged. The validity of the agreement for sale, that argument and that position was also carried over in the Court of Appeal by both the appellant as well as the respondent. So all parties are in agreement that at all pertinent times, this agreement for sale, and to this day, milady, this agreement for sale is still valid.
Ms. Hepburn, could I just ask a question? And that is, if your argument about 62 subsection 2 is correct, what is left as having any point of having 62 subsection 1? What would the substance of 62 subsection 1 then be about? Because, as I understand it, it would seem to me your argument would say you only need 62 subsection 2.
No, my lords, the reason that section 62 subsection 1 is important is because it shows that Parliament's intention in an attempt to regulate the planning and subdivision of communities in the Bahamas, they did not wish for any conveyances after the act came into effect to continue on. And so section 62 subsection 1, this was the position laid out. However, my lord, understanding the legislature, understanding that you cannot implement this act and affect the ongoing sales transactions, section 62 subsection 2 was implemented in an effort to protect those who not only received conveyances before, but those persons who had yet to complete their transactions. And so, my lord, in its totality, we are presenting before you the importance of section 62 in its entirety.
Yes, but could I just ask you, subsection 1 is dealing with conveyances, and after the act, conveyances regarding lots not granted prior subdivision approval are null. And then we get subsection 2, and in the part we're looking at, all it is doing is saying that the agreement entered into prior to the act, of course, is not null and void, but it doesn't say anything about the conveyance.
Lady, in subsection 2, it refers to both agreements as well as the conveyances after the act. And milady, if I may take you to paragraph 24.
Could I just pause?
My written case. Mm-hmm. Milady, at subsection 2, it states, notwithstanding, and I'll just read it for the record, notwithstanding subsection 1, where the beneficial owner of a lot in a subdivision prior to the commencement of this act conveyed or agreed to convey land within the subdivision, but failed to obtain the approval of the town planning committee as well as the approval of the minister. Such agreement to convey or conveyance shall not be null and void due to the failure to obtain the approval under subparagraph A and B, and any person who obtained title to a lot within the subdivision shall not be prejudiced. And so, my lords, that bottom portion, which speaks to both the agreement to convey, which in our case is the agreement for sale, which the other side has accepted is still valid, and then it goes on further to state or conveyance.
But it's such agreement or such conveyance. One must read it that way. I mean, it's such agreement to convey as a reference back to an agreement which is prior to the commencement of Act, and such conveyance is referring to a conveyance prior to the commencement of the Act.
My lords, and this is the reason why, my lords, we indicated that if we were to refer to section 62, subsection 1, this refers to specifically conveyances made after the Act. And for this reason, subsection 2 starts off with notwithstanding, because there is a clear indication that conveyances will be made after the Act if the agreement to convey is preserved.
If I may just add to the point Lord Hodge put to you, if one reads on within subsection 2, first of all, in the final paragraph, as my Lord points out, it's a reference back to such conveyance or such agreement to convey, that is to say, a conveyance which has occurred before the commencement of the Act. And if one reads on, it says, and any person who obtained title to a lot shall not be prejudiced. It doesn't say, or who obtains. So doesn't that perhaps support the same reading, that this is all looking back to conveyances which took place before the commencement of the new Act? And it says nothing, subsection 2 says nothing about the effect of conveyances which might have to take place after the commencement of the new Act.
Respectfully, my lords, our position is that the obtained title, it does not specifically set out an equitable title or legal title, my lords. And this is something that we refer to later on in our argument. It's stating that a person who obtained title will not be prejudiced. The legislature did not state who obtained legal or equitable title. And for that reason, my lords, we are of the view that the respondent having gained an equitable title will not be prejudiced.
So if I can understand that submission, I think what you're saying is, by that submission, you accept that the past tense of obtained is referring to the period before commencement of the new Act, but you say that there was a title that was conveyed prior to the commencement of the new Act. Is that right?
My lord, what I am saying is that the portion pertaining to obtained is that they obtained by virtue of the agreement to convey their title in this particular property. And so it is our submission that the respondent has already obtained his equitable title to this property. And so it's not, the Lord, he would have already obtained it previously.
Yes, thank you.
Ms. Hepburn, I wonder if I can ask you a question, as Lord Briggs at this end. It's probably the law of the Bahamas, but confirm, if you would, that generally speaking, someone who enters into an agreement to buy land in the Bahamas obtains equitable title pursuant to the agreement. And that's the basis of the submission which you've just been making, I imagine. I can see you nodding. I'll take that as a yes.
That is correct. And later on in my submissions, I will refer your lordships to a particular case as well, the Dalton case, which I'm sure you're very familiar of, where the legislation in that particular case makes a distinction between legal and equitable interest. And that was a legislation that predates, my lord, the Planning and Subdivision Act. And so if it was the intention of Parliament to distinguish between legal and equitable title, my lords, it is our humble submission that they would have done so in section 62.
And I understand that, but is it also part of the law of the Bahamas, as it may be suggested to you that it is part of the law of England, that the basis upon which a purchaser under a contract for the sale and purchase of land obtains equitable title is because the contract is usually subject to specific performance, i.e. you can get a court order for a conveyance, and that it's because of that that you get equitable title?
Yes, my lord.
And if that's so, could the court under the old Act have ordered specific performance of a contract to convey land if at the time of the, I suppose, hearing, the relevant planning permission hadn't been obtained, so that a conveyance would have amounted to a criminal offence?
Well, my lords, in that particular case, and we would later refer you to the Oceana case,
Yeah.
my lord, in the way in which the act was read previously, it would have made a vendor subject to a fine for breach of the legislation, but it did not invalidate a conveyance.
No, but the question isn't whether the conveyance is invalidated. The question is, could the court in equity enforce a contract by ordering a conveyance and thereby authorising a criminal act?
Well,
Well, my lord, in that
criminal
particular circumstance, as section 62 subsection 2 was not enforced at that time, our position would be that the court was stopped from ordering or making that order.
The court would? I'm sorry, I'm not sure I heard you.
No, the court would not have been able to make that order as section 62 subsection 2 was not in effect as yet.
So you accept, do you, that the court under the old Act, if this case had come before the court before the new Act came into force on an application for specific performance, the court, with no planning permission in existence, the court would not have ordered specific performance?
Well, my lords, if we were to follow the principles under the Oceana case, that would be our submission.
Yes, I think
under the old Act, my lords, an order such as that would not have been able to be made.
And if that's right, how is it that this contract and any contract for the sale of land made at the time of the old Act could create an equitable interest in the buyer at a time when there wasn't any planning permission, so no court would order it to be specifically performed?
Well, my lord, as noted in the rulings that we would have presented in the case, entering into the agreement, and my lords, I have it noted in my written case as well. Inside of the particular section, it refers to, and it would be the case of Oceana. Lord Newburgh said that the entering of the agreement does not invalidate the agreement in any shape or form. And so, my lord, it is our humble submission that the rights under that agreement, being the equitable rights as well, which still exist, that equitable title, my lord, is received upon the entering of the contract and the payment of the deposit, my lord, and that is not subject to any particular fine or sanctions.
Thank you.
I'm much obliged, my lord. My lords, I would have pointed out at that particular time the agreement for sale still being valid, and we wanted to, in our humble submission, put forward to the court that the interpretation of section 62 in the Court of Appeal was flawed for a number of reasons. Firstly, my lords, we say that the legislation preserved not only the agreements, but the conveyances flowing from that agreement. This we submit is clearly read in the legislation. Secondly, we submit that in the normal scheme of sales transactions in the Bahamas, sales are completed within 30 to 90 days. The process for subdivision approval, however, could be up to 4 months or even longer. And so it is illogical to think that Parliament would save the agreement for sale but would not save the conveyance from that agreement for sale, but would expect the vendor to now scurry to satisfy the criterion, which is under the new act, in hopes of closing the sales transaction within the allotted time frame. And Lords, it is important at this point to note the distinctions because the justices of the Court of Appeal took the view in their ruling that the vendor should just go out and do what they were always required to do. However, although there was some form of approval required under the old act, the requirements for approval under the old act and the new act are not one of the same. My Lords, we have certainly set out what those new requirements are under paragraph 34 of our written case, and we will not read through that, my Lord. However, admittedly, the requirements under the old act were not as vast or as stringent, and as such, the old act consisted of about 15 pages that was enacted in the 60s and some over 45 years ago. And, my Lord, those requirements were not being enforced or complied with. My Lord, this position was accepted by the then Prime Minister of the Bahamas, the Right Honorable Hubert Ingram. My Lord, this is just for future record purposes. This can be found in the electronic full bundle at MS 1362, the official Hansard, where the Planning and Subdivision Bill was presented. And in that, my Lord, he states, and I do not suggest at all that the private sector alone has done these things. The government has also been guilty, Mr. Speaker. The reason that we wish to point this out to the court is that in their ruling, the Justices of Appeal stated that it would be nonsensical to think that Parliament would make provision for a vendor who acts in breach of legislation and is thereby guilty of a criminal offense. However, my Lords, we submit that this is not the specific approach which was being taken by Parliament. Simply put, my Lords, the draftsmen, the legislature, the Bahamian people had an appreciation of the fact that there were practices where families who may have owned large acres of land divided up their property and gave to their children without approval. Developers divided up properties and sold to others, and even the government was guilty of dividing up property and building on these properties without permits and without conveying it. And it was based on this understanding of this widespread practice of what was occurring for over 4 decades that the legislation implemented in Section 62 did 2 things, my Lords. It says, okay, the government, family members, developers, vendors, all of you who have an ongoing agreement and investments that are ongoing, you finish those deals. You execute your conveyances, because moving forward, any future transactions that were not pending before this act passed shall not be allowed. And this approach, my Lords, are in line with the objects and reasons found in the Planning and Subdivision Bill. And for future record, it's found at M61269 of the bundle. And clause 62 of the objects and reasons sets out that the purpose of Section 62 was to preserve a transaction in respect of a lot in a subdivision which did not obtain the requisite approval. And so, my Lords, just as a final point under this particular point A of my first round, we referred to the Justices of Appeal's failure to take into consideration the overall principles of a Repeals Act, which is found at Section 20 of the Interpretation and Clauses Act. It states, where a written law repeals in whole or in part, or any other written law, the repeal shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any written law. My Lord, this brings us back to the distinction we referred to earlier, that approval under the old act and the cost and liability of a vendor that he would occur under the old act is entirely different from that of what would occur in the new act. And so, my lord, whilst the learned justices of appeal rule that a vendor should just go out and do what they were always required to do as a result of the Planning and Subdivision Act, it is our humble submission that they were unable to do so. The old act merely required that you insured private roads, electricity, water, and gave no regard to protection of environmental wetlands and environmental impact assessments to be done, and ensuring that particular portions of the subdivision has allotted space for a park and community services. And so, my lord, it is our position that the interpretation under this portion alone, my lord, is flawed. And my lord, if I may move to part B of my first ground, and I won't cover the
Just before you,
the implications.
Lord Briggs would like to ask you a question, Ms. Hepburn.
Just before you do, Ms. Hepburn, this is really a point of information for me because I'm not familiar with this particular planning process. Assume that there is a contract for sale, such as this one, which is awaiting completion, and permission was not obtained at the time of the contract. Is that something which in theory could be obtained by either the vendor or the purchaser, or is it something that only the vendor can obtain?
My lord, that can be obtained by the vendor and the purchaser.
Thank you very much.
And my lords, just for record purposes, in the case, in my written case, I refer to a case ruled by Justice Winder, the Scott case. And like I said, my lord, I won't go in great detail on that, but in the Scott case, Justice Winder also makes the same reference, Scott versus First Caribbean International Bank. And my lord, if I may just to fully answer your question, at paragraph 91 of my written case, it says, the Honorable Mr. Justice Ian Wire ruled that whilst it is true that the attorney did not ensure that the subdivision approval had been obtained, the law provides that title to the property nonetheless passed to the plaintiff and that she is the owner.
Do you have a page number for that?
Pardon me, my lord?
You have a page number that you're looking at?
Oh, I'm on MS 977 of my
Thank you.
written case.
Yeah.
And my lord, in that case, we said that the defendant in that case argued that failure to obtain subdivision approval may not have been fatal, as the plaintiff may have been able to achieve severance approval from the Town Planning Committee. Section 45 of the Planning and Subdivision Act 2010 provides, upon application by the landowner, the committee may consider an application for severance approval made under Section 36 for severing not more than 4 new lots from an existing lot, adding land to an existing lot or lot line adjustments, rights of way, or easements. So that is just a reference to a case which also dealt with that matter, in which the purchaser is also able to make a severance application. Well, Lords, if that has addressed the question, may I proceed?
Please do.
Much obliged.
Thank you.
Well, Lords, as I had indicated, I'm not going to go in great detail at paragraph B of the first ground of appeal, the implications of the Court of Appeal ruling. However, I do wish to state, my lords, that the current ruling of the Court of Appeal shall result in a potential floodgate of potential claims by purchasers whose conveyance, after having relied on Section 62, would now be considered null and void. In fact, my lords, a similar circumstance previously occurred in the Oceana case, and my lords, I shall refer to this case in greater detail later in my submissions. However, my lords, you would note that the Honorable Earl D. DeVoe, the then Minister of Environment, when discussing the Planning and Subdivision Bill in Parliament, he made mention of a similar floodgate which occurred as a result of the ruling of Justice Lyons, which was later overturned. And for future records, this can be found at MS 1303 of the electronic bundle. In that particular presentation, he stated, this bill comes at a time when the conveyance practice, legal profession, and subdivision developers are faced with the August 2008 decision by the Honorable Mr. Justice Lyons. Justice Lyons' ruling is summarized from paragraphs 57 onward. Essentially, he rules that conveyances of lots in subdivisions where no final approval had been granted for a subdivision by the minister responsible under the Private Roads and Subdivisions Act 1965 were illegal and invalid. As a result of that ruling, many law firms had to seek a court's permission to issue a conveyance. My lords, it is clear based on this statement alone from the then Minister of Environment that a ruling of such invalidating conveyances creates a floodgate of court actions in which an attempt is made to either validate conveyances, allow agreements to convey to proceed. And it is our humble submission that the legislature saw this and understood this. And for that reason, the Planning and Subdivision Bill was sought to fix the errors involved in that ruling. My lords, if we may now go to Part C of my first round of appeal. My lord, this just touches on the respondent's claim for breach of the agreement for sale. My lords, once again, I have presented this in my written case, so I won't go into great detail for Part C. However, we just wish to point out to the court that the respondent's claim was for the return of monies prior to establishing whether or not subdivision approval was a requirement in this transaction by a court of law. We say that this is an important point because the respondent is claiming that the appellant breached the agreement, and it was alleged that the breach was as a result of the appellant's failure to obtain subdivision approval. However, based on the arguments presented in the Supreme Court, in the Court of Appeal, and this court herein, the respondent was seeking the court's verification on whether subdivision approval was needed. On this ground, my lord, we respectfully say that the case presented by the respondent was clearly prematurely brought, and the proper course of action that ought to have been taken was a Section 4 application, most commonly known as the vendor purchaser summons. Now, my lord, just to go to Part D of Ground 1, my lord, and Part D sets out arguments regarding the rights and interests. You will note from the respondent's written case that they averred to 5.11, stating that the vendor retained all rights to the property until its final payment in 2013. However, my lords, it is our respectful position that this is clearly incorrect, not only in law, but in the agreement for sale itself. My lords, you will note in the actual agreement for sale at clause 7.11 that it states that should the purchaser fail to make any payments towards the balance of the total purchase price, the vendor shall have the right to immediately cancel the agreement, and any of the purchaser's rights in the lot shall revert to the vendor. And my lords, in our written case, we drew reference to the text of McGarry and Wade, where it affirms how the purchaser becomes the owner in the eyes of equity from the date of the contract, and how it is irrelevant that the date for completion has not arrived. We also referred to Black's Law Dictionary, where the definition of an equitable interest is an interest held by virtue of an equitable title or claimed on equitable grounds. And so, my lords, it is clear that in law and in the agreement, there is a clear acknowledgement that the purchaser has rights, which can only be taken away if he defaults or breaches the terms of the agreement. And that has not occurred, which is why the agreement to this day is still valid. And my lords, if I may go to Ground 2 of my written case, and that's found at MS 974. My lords, in the respondent's case, it was submitted that the court was granting the appellant an indulgence in order for the appellant to pass the title to the respondent. I'm sorry, my lord?
No, there's no one interrupting you. Please continue.
Oh, my apologies.
Not at all.
It stated that the appellant was being given an indulgence in order for the appellant to pass good title to the respondent. However, my lords, it is our submission that subdivision approval is not a requirement that is needed in this case for good title to be passed. And there were two main cases, and I would have referred to them earlier, my lord, which we rely on those principles to provide a clear indication of why the appellant should be allowed. And I know my lords would have already read these cases, and so there's just specific parts that I would like to point out, special notation to the court. My lord, firstly, the Oceana Heights Limited and Willard Clark Enterprises case, I wish to speak to the Privy Council ruling. And in this case, I wish to point out that in the Court of Appeal, the justices rightly found that Justice Lyons was wrong to conclude that the effect of Chapter 257 was to render the conveyances and the contracts pursuant to which those conveyances were made void. They found that whilst the conveyances and antecedent contracts were executed by WCE in breach of Sections 5 and 7 of Chapter 257 and rendered WCE liable to prosecutions and fines, it held that those statutory provisions did not invalidate the conveyances, which were therefore effective as against Oceana. My lords, in the Oceana case, the Privy Council drew reference to the Court of Appeals ruling, and you will note that the respondent in his written case emphasizes a portion of the Privy Council rulings. And my lords, it is our position that it misleads the court as to the true position of what was being said. Lord Neuberger stated in his ruling that the court at that time could not simply have ordered the 11 lots be conveyed in breach of a statutory prohibition. Notably, my lords, it is important to point out that at that particular time, when the ruling of the Court of Appeal was made, the Planning and Subdivision Act did not apply to the island of Exuma. And so when Lord Neuberger spoke of the Court of Appeal's inability to convey in breach of a statutory provision, that was due to the fact that there was no Section 62, subsection 2, that the Court of Appeal could refer to. And you would note throughout its ruling that that particular court, the Court of Appeal, made no reference to the Planning and Subdivision Act. And, my lords, just for reference, the Planning and Subdivision Act applied to the island of Exuma in 2011. My lords, in that particular case, Lord Neuberger goes on further in the Privy Council ruling to state that while it was not relied on in terms by the respondent, and he's referring to the Planning and Subdivision Act, the board, to put it at its lowest, takes considerable comfort in reaching this conclusion from the terms of Section 62 of the new Planning and Subdivision Act, which came into force subsequent to the decision of the Court of Appeal and inter alia repealed and replaced Chapter 257. And so, my lords, the assertion in the respondent's case that we are seeking to the court to grant an order that the Privy Council stated could not be done, it is our submission that that is flawed. The Privy Council in the Oceana case said that the Court of Appeal could not order it, and that's because we submit the Planning and Subdivision Act was not enacted, and I believe we addressed this earlier as well, my lords. And, my lords, we submit...
Does it follow from that submission that you say that Section 62(2) puts the party seeking to enforce the contract in a better position now the new Act has been passed than that party would have been under the old Act?
No, my lord. And the reason for my answer is that under the old Act, if this conveyance was completed in 2009, my lord, the conveyance would still be valid. And so it is our submission that pre-Planning and Subdivision Act, you would still have a valid conveyance. And post-Planning and Subdivision Act, you would still have a valid conveyance, because in the previous legislation, it merely created a prosecution on fine. It did not invalidate the conveyance.
The reason for my question is that, as I understand Oceana, but tell me if I've got it wrong, the board did say, under the old Act, as you rightly say, because although the new Act had been passed, it wasn't at the relevant time, as I understand it, in force in relation to exuma, that the court would not, under the old Act, order a conveyance pursuant to the contract.
Well, my lords, it is our position that the court certainly wouldn't order that conveyance, but that did not mean that a conveyance could not be drawn
Oh, no,
up.
of course. But if that was the position under the old Act, the court couldn't order a conveyance now that the new Act has come into force in relation to exuma, unless Section 62(2) puts the person seeking such an order in a better position than that person would have been under the old Act.
And my lords, it is our position that that is not the case. Under the old Act, respectfully, there would be no requirement for a hearing or a case, because under the old Act, there was no legislature which invalidated conveyances, making them null and void. And so at that particular time, a court, if approached with that, my lord, they certainly would not have the requirement to make that form of an order.
Thank you.
I'm much obliged. Lords, we submit that the justices of appeal in the case herein misconstrued the facts of the Oceana case. The Honorable Justice Milton Evans, in his findings, stated that the reason that the court ruled as it did in the Oceana case was that it was clearly a policy decision by the court as to declare the transaction void, and would leave the purchaser without title and having to chase the vendor to recover monies paid for the property. He further goes on to state that it was also inconceivable that persons may have also already begun construction, so their loss would be magnified in those cases. And my lords, we just wish to point out that in the Oceana ruling, it was made clear that an indemnity agreement existed and went on record, stating that if any of the intending purchasers had brought proceedings, Oceana would be the one who would have taken full responsibility for legal and other costs, liabilities, and expenses incurred. And so it cannot be based on the Honorable Justice Milton Evans ruling that this was the reason that Oceana, that the court, the Privy Council court, made that particular ruling. And so, my lord, the principles and conclusions found in Oceana were certainly not as a result of a policy decision, but founded in law. And the learned justices of appeal, as well as the respondents, have placed an extremist position and has been fixated on whether the entering of contracts was a criminal offense. And it is our submission that this fixation on the criminal offense aspect of the old Act has impeded the learned justices of appeal ability to apply the correct interpretation of this legislation or appreciate the principles in the Oceana case. And my lords, I just want to, this quickly brings me to the second pertinent case authority, my lords, and that is Dalton versus Lyford Key Action number 1187 of 1983. And this was heard in the Supreme Court of the Bahamas.
I'm so sorry, Lord Sales here. If we're leaving Oceana, can I just check a couple of things on it? So I'm looking at page, I think it's 1598 in the MS.
1598?
Yeah.
Yes, my lord.
This is Lord Newberger's discussion of the arguments in that case. Paragraph 16, he says, just because under the old Act it would have been a criminal offence to convey, it doesn't necessarily follow that the contract or conveyance itself is void. Paragraph 17, the facts of that case were that WCE actually conveyed the 11 lots to the purchasers at a time when it was forbidden. So they had effected a conveyance, even though that was in breach of the criminal law. At paragraph 16, Lord Newberger says, see the last sentence, because it would have been a criminal offence to convey, If the conveyance had not yet taken place, the court could plainly not have ordered WCE to convey individual lots in breach of a clear statutory provision. So that seems to be Lord Neuberger saying clearly that there could not have been an order for specific performance in that case. And then he distinguishes that position from that on the facts of the particular case. At paragraph 17, he says that does not mean that if, as happened, WCE actually conveyed the 11 lots, the conveyances were thereby invalid. And in paragraph 19, he is focusing upon whether the legal conveyances that had in fact taken place in that case were valid or not. So I'm drawing your attention to these features of the case so you can deal with it. Lord Neuberger seems to draw a clear distinction between an unexecuted contract where the completion of the contract involving a conveyance would involve the commission of a criminal offence by the vendor, and says that the court would not order specific performance in that case, and distinguishes that from the case he was actually dealing with, where a conveyance had in fact occurred, and he was looking at whether the Act had the effect of making the conveyance of legal title effective. Now, if that's right,
yes,
isn't that a problem for your case?
My apology, my lord?
I said, if that is right, if Lord Neuberger is saying that specific performance would not be available at the time when the contract remains unexecuted, is that not a problem for your case, since equitable title depends upon the availability of specific performance?
My lord, I would respectfully disagree. And we noted earlier on during our submissions, if you would recall, I made reference to the fact that Lord Neuberger, at this particular paragraph, he was speaking to what the Court of Appeal could have done. And so the wording spoke to the court could plainly not have ordered. And he's speaking in the past tense, my lord, because at that particular point in time, the court was still subject to the Private Roads and Subdivisions Act. And that's why you will note in the previous ruling under the Court of Appeal, there's no reference made to the Planning and Subdivision Act. There is no Section 62 savings clause preserving persons who received equitable title. There's no savings clause in which persons had obtained title and would not be prejudiced. And so at that particular paragraph, Lord Neuberger is stating that previously the court could not have ordered this. And previously, it would not have invalidated the conveyances. And so, my lord, respectfully, what Lord Neuberger in that particular section does is he refers to the past tense of what the Court of Appeals position was at that particular time. And thereafter, I would have drawn reference to the court of further comments made by Lord Neuberger to state that they were comforted in reinforcing that order of the court because of the Planning and Subdivision Act, which was not in effect at the time of the Court of Appeals ruling.
Yes, thank you very much.
I'm much obliged, my lord.
Ms. Hepburn, you're of course, you're not claiming specific performance in this case, are you? As I understand it, in this case, your opponents are claiming their money back. You're simply saying you've offered a voluntary conveyance. Their title could not be adversely affected by the new Act because of Section 62(2). And they can't, by refusing to take the conveyance which you've offered, say that you're in breach of contract, so they're entitled to their money back.
Yes, my lord.
Yes.
It is our humble submission that the appellant in this case has always been willing and ready, and you will note from the previous emails from the previous attorney, Mr. Andrew Wells, that the vendor has always been ready and willing to present a conveyance to the respondent in this case.
And you say it's not a legitimate requisition on title that you haven't got planning permission because of Section 62(2).
That is correct, my lord.
Yeah, I understand. Thank you.
And my lords, we're also just stating for the court's record as well that the claim was premature in seeking for the monies back rather than approaching the court on the correct interpretation of Section 62. My lords, if I may now go to the case of Dalton, and just to quickly set out just a few principles in that case as well, my lords, which we would wish to note for the court. My lords, you will note in the respondent's written case that it was argued that because there was no previous legislation, this is why the court was able to make an order to allow the conveyance to be issued. However, my lord, the wording in the Immovable Property Acquisition by Foreign Persons Act, it was stringent, and a court certainly could not just allow without particular provisions being in place, my lords. And my lords, in that particular act, and I'll just read Section 5, subsection 1 of that act, it stated that no foreign person shall acquire or hold any immovable property in the Bahamas except under the authority of a permit granted to such foreign person by the board. And every conveyance which is not made under the authority of a permit purporting to convey any immovable property to any foreign person shall be null and void and be without effect for all purposes of law and in regard to all persons, and no interest whatsoever, whether legal or equitable, shall pass to such foreign person by reason of such conveyance or any other matter. But the foreign person shall be entitled to recover with such legitimate deductions as may be justified in law any and all monies paid by him as consideration for the said conveyance. My lords, you will note in this case, similar to the Planning and Subdivision Act, that there is a clause provided which attempts to protect persons who may have acquired or is acquiring land. And this particular savings clause was found at Section 17 of the Immovable Property Act. And Section 17 starts off, my lord, notwithstanding any other provision of this act, nothing in this act shall be construed so as to take away or diminish any rights, privileges, or capacity heretofore lawfully held or possessed by or belonging to a foreign person so far as related to the holding, possession, or enjoyment of immovable property or any interest therein or any personal property in the Bahamas. And so, my lord, Dalton, who was a foreigner in the Bahamas, notwithstanding the stringent position in Section 5, subsection 1, the court was able to order, despite the legislation saying that no conveyance could be issued without that permit, the court made an order that the conveyance be issued to him without a permit. And so we are inviting this honorable court, in reliance of those principles set out by the Privy Council in the Oceana, as well as the principles set out by Justice Adams in the Dalton case, to find that the appellant does not have to receive subdivision approval in order for the respondent to receive good title. And my lord, that would take me to grounds 3 and 4 of my submissions. And my lords, if I may just have 5 minutes to 5 to 7 minutes to just go through those 2 grounds quickly.
Yes.
Because we do note that it was I believe there was somewhat of a break. I believe maybe a 7-minute break earlier.
Yes.
I'm much obliged, my lord. My lords, I would have touched on and pertaining to ground 3, which deals with there being no prejudice to the learned justices of appeal erring and finding that there was no prejudice to the vendor in requiring him to receive subdivision approval. My lords, I touched on this point a little earlier in my submission, regarding the clear differences of which subdivision approval pursuant to the new act versus ministerial approval pursuant to the old act, and the clear cost and liability differences in that, my lords. My lords, as I indicated before, under the new act, a vendor was now required to conserve wetlands. They were entitled to make sure that the adequacy of community services, including schools and clinics, were nearby. There had to be flood control policies put in place, preservation of environmentally friendly land, along with protection of certain forestries, my lord, as well. And my lord, this pales into comparison to what was required under the old act, which was more ensure that there were roads and running water. And so, my lord, under at the time of the entering into the contract, this was certainly not a criterion that any vendor considered when executing an agreement for sale, and certainly when considering the cost in that agreement for sale. And so the time and cost for a vendor to now ensure that the extensive criterion is satisfied within that short allotted time that we know in the Bahamas to be 30 to 90 days, that certainly cannot be the intention of Parliament, my lord. And so respectfully, we say in some regard, the vendor is prejudiced as he is now required to satisfy this extensive criterion. And as we have pointed out in our written case, the learned justices of appeals ruling appear to follow more so the principles founded by Justice Lyons, his ruling, which was overturned, which focused solely on the fact that it was a criminal offense and it was illegal and they ought to have done something before, so they need to go and do it now. But the Privy Council in the said case correctly pointed out that where a statute imposes a penalty as a result of entering into a contract, the court will consider whether on the construction of that particular act, if it is forbidden or merely a charge imposed upon it. And so in the case herein, my lord, we state that there was simply a charge imposed upon the appellant herein in entering this agreement for sale. And my lord, as a result of the conveyance not being executed as a result of the respondent not making final payment until 2013, the appellant is now in a position to proffer the respondent with a conveyance in reliance of section 62 subsection 2 for good title to his property. And my lord, just as a final point, ground 4, which speaks to, my lord, the learned justices of appeal erring in finding that section 62 subsection 2 was enacted for the protection of the purchaser. And my lord, our written case sets this out, and as mentioned earlier, it is our view, my lord, that section 62 was enacted for preserving a sales transaction. And this is our view because this is what Parliament stated in its objects and reasons to be the purpose of section 62. This position that it was just for the purchaser, we submit, my lord, that it is unsound. However, my lords, even if we were to take this argument and my lords, whilst we are of the view that section 62 is to protect all parties in a transaction, if we were to consider the argument that section 62 subsection 2 is for the protection of the purchaser, my lords, then the learned justices of appeal, as well as the respondents, are affirming the position that Mr. Momin, the respondent herein, that he is protected under section 62, subsection 2. Then the final ruling which the learned justices of appeal found is unfounded, my lord, and respectfully, we say that it is flawed. Because if he is protected and it was enacted for his protection, how can we now say that the conveyance pursuant to that protection would be null and void? And so respectfully, my lords, that would be our submission. And my lords, we are not asking this court to interpret or any other statutory interpretation or arrive at a ruling for a matter that has never been explored and tried before the courts. My lord, as indicated before, there's an unreasonable focus on the criminal factor and aspect of this case. However, my lord, we submit that the legislation is clear. The case authorities are clear. And the only clear finding should be that the respondent is able to receive the conveyance pursuant to section 62, subsection 2, without subdivision approval. And if it may please, my lord, that would be the submissions on behalf of the appellant.
Ms. Hepburn, thank you very much. The board will adjourn for 5 minutes to consider its position on this matter. Thank you. Mr. Wilson.
My Lords, we say 4 things. The first 2 relate to statutory interpretation, the third to good title, and the fourth to discretion. First, the language of section 60 is plain. Parliament intended that every single conveyance made after the Act came into effect regarding lots not granted prior subdivision approval shall be null and void. There is no escaping the word any in section 62(1). Section 61. Second, nothing in section 62(2) qualifies subsection 1 as the saving clause in subparagraph 2 only applies to conveyances made before commencement of the Act and not to conveyances made after it. There's a clear distinction. You have the genus conveyances, you have the specie after the Act came into force, that's subparagraph 1, and you have the specie before it came into force. There are no words in that section which mixes the two. Third, at no time was the appellant ever in a contractual position to give good title to Dr. Momin, given its failure to obtain the approval of the minister under the old Act and the failure to obtain any subdivision approval since the new Act came into force. The test for good title is whether the court, in an action for specific performance at the instance of the vendors, would force a title containing the alleged defect upon a reluctant purchaser. Emit on title, it's referred to in the electronic bundle at 2019, paragraph 5.002. A court sitting with an equitable jurisdiction and properly exercising its discretion would not force a reluctant purchaser to accept a conveyance prohibited by statute and, more to the point, which at the time would amount to a criminal offence. That was the position under the old Act, and under the new Act, such conveyances are still prohibited by reason of section 49 of the new Act, and a criminal offence under section 61. A court sitting with an equitable jurisdiction would be particularly disinclined to make an order for a specific performance at the instance of a vendor who had already committed a criminal offence by entering into a contract of sale in the first place and was now seeking the court's assistance to either commit a further offence or act in a way which was prohibited under section 49 of the new Act. The hands of the appellant in a court of equity would look very mucky indeed. And so I come to the fourth thing that we say.
Would I be right to say that under Section 5 of the old Act, it was a criminal offence not only to convey, but to enter into a contract of conveyance.
Yes.
Yes. So the agreement itself gave rise to a criminal offence. But what Section 62(2) said, that it wasn't ipso facto null and void.
Yes.
But you say, okay, the agreement isn't null and void, but the conveyance that follows upon it is struck at by Section 62(1).
My Lord, yes.
Yes.
Things may be unlawful, prohibited, they may even be criminal. It can still be valid, but what we're talking about here is the question of good title, ultimately, and whether a decree for specific performance would be issued. And so, my lords, the fourth thing that we say is that the Court of Appeal, having ruled, and we submit ruled properly on Parliament's intention, as shown in Section 62, properly exercised its discretion by making an order allowing the appellant a further 30 days. And I hear my learned friend say, well, 30 days for subdivision approval, that's not very long. Well, they've had since 2008, and they simply haven't done it. And it would appear, reading between the lines, that they had no intention at any point in seeking subdivision approval.
Can you just tell me what discretion was the court exercising? You came to court, as I understand it, to say this contract can't possibly be completed, conveyance will be void, and I want my money back. But how did the court exercise a discretion to give 30 days? Well, nobody was, as I understand it, asking for specific performance, were they? Was there a counterclaim for specific performance?
My lord, no.
So what discretion did the court have?
Well, we describe it as an indulgence to the other side. But it was an indulgence that they were at liberty to make. It couldn't be said that it was an irrational indulgence from the point of view of the purchaser, Dr. Momin. But in any event, they decided to give them one last opportunity, right. Which the appellant, as it had done for the previous decade, declined to accept or even try.
Can I just ask, when you were claiming the money back, what was the basis for that? Were you alleging breach of contract by the other party, and you've terminated the contract in some way? Is that how you conceptualized it?
The allegation was breach of contract in the sense that they were not able to give good title to the property because of the encumbrance, and clause 513 of the contract made it quite clear that at the time of completion there must be no encumbrances whatsoever. And the view that was taken, as you will have seen in the correspondence between the respective attorneys, so for Dr. Momin, the point was taken that you haven't got subdivision approval. Please confirm whether you've got it or not, because if you haven't, that's something which goes very much to title and giving good title, because without it, there would be enormous difficulties for Dr. Momin down the line. For instance, if he came to a point where he wished to sell the property. And long before then, if he wanted to sell it, he'd have to get subdivision approval, which could cost not only hundreds of thousands, but millions of US dollars, because we're talking about putting in roads, putting in utilities, and bearing in mind that he purchased lot 36, so we know that there were at least 36 other lots. No evidence has been produced at all by the appellant that they actually got subdivision approval in respect of any of those lots. And so this is a very onerous matter to put on a man who's already given them nearly $1 million US that they have had since 2013 in full. They've sat on it, and to put him then in a position where if he were left with having to complete the conveyance, he would have a tidy sum to have to pay out if he wanted to get subdivision.
But the answer to my question then, as I understand it, is that you were alleging breach by the inability to provide good legal title, that is breach of clause 5.13, I think, free and clear of all encumbrances.
Yes, because 513 as well makes it clear at the time of the conveyance, at the time of completion, there must be no encumbrances whatsoever.
Yes, thank you.
My Lords, those are the principal matters that we rely upon. We say that the words of Section 62 are absolutely clear, that in those circumstances, as there's no ambiguity, there'd be no need to look at the other interpretative rules, but we can do so because we say that within the Court of Appeal judgment can be seen reference to the purposes rule, and in fact there would have been a statutory duty on the Court of Appeal to have regard to it. Section 3 of the new Act says that any matters, questions of interpretation are to be determined according to the purposes and the objects, and the Court of Appeal had regard to that. We can go into detail on that. We've set it out in our case, but there are further matters as well, which are within the Act. If one looks at Section 3.1, the objects and purposes are set out there. There is the question of the mischief, which can be looked at if it was felt that so far as the plain meaning rule was concerned, that there was any ambiguity. We submit respectfully that there isn't. But again, if one looks at the mischief rule and what was said, in fact, as long ago as Hayden's case in 1584, that the duty of the court is to further the legislature's aim of providing a remedy for the mischief against which the enactment is directed. And then these words, that the office of all judges is always to make such construction as shall suppress subtle inventions and evasions for continuance of the mischief pro privito commodo, for private advantage. And that judicial observation is now, well over 400 years old. It has stood as a veritable rock of interpretative principle against the waves and weathers of time. And it was a rock that the Court of Appeal itself recognized in its reasons.
Yes, but if I may just put this point to you, when we look at the context in which legislation has been passed, we have always to be sure that what was identified as the mischief in the pre-existing situation has in fact been the cause of the particular provision we are looking at. Now, in this case, just to put one point to you, the explanatory memorandum for the Act says that the provisions of Section 62 are for the protection of transactions. It doesn't say protection of purchases, if I just put it simply that way. And if you look at Section 62, you can see that to some extent it is adverse to the interests of purchasers. So I think we need to get down, not into, I think the Hayden's case is quite familiar to us, we need to get down to the granular examination of the legislation.
Well, my lady, certainly. And so, having stated the four key points that we take, we propose now to move to the question of the interpretation of Section 62. And what we propose to do is to look at what the Court of Appeal itself plainly did on the question of interpretation. First, Section 62 correctly interpreted, we submit, means that any conveyance made after the Planning and Subdivision Act 2010 came into effect regarding lots not granted prior subdivision approval shall be null and void.
That's subject, isn't it? In spite of, I think it was put, subsection 2.
Not in spite of, because that is unqualified. Subsection 2 does not qualify any conveyance after the Act not having obtained subdivision approval.
The provisions of the final part of section 62(2) protect the purchaser who has obtained title, but that, of course, is before. Yes, I can see the way you put that.
Yes, that's where the title's been obtained. For instance, the circumstances in the Oceania case, where the conveyance has already occurred and title has been obtained, and what Parliament was essentially doing there was saying, in the sort of circumstances that you have in Oceania, where the conveyance has already taken place, then the purchaser should not be prejudiced. And it may be that the purchaser in those circumstances, as the purchasers in Oceania, may want to keep the property, may want to have title and have proper title. But there would be other circumstances where it would amount to a very considerable prejudice to the purchaser. And what subsection 2 is saying, that such a person should not be prejudiced. It's impossible to read subsection 2 in the way in which the appellants do, which is it's there to protect both the vendor who has broken the law and committed a criminal offence, and also the purchaser. There's no way in which that can probably be read consistent with that suggested interpretation.
Is who is intended to be protected really at the heart of this? What's at the heart of this is what is the extent of the protection. And your case, put very simply, is section 62(1) says what it says. Section 62(2), using the word notwithstanding rather than in spite of, is a clarification of what is not covered by section 62(1), and that is such contracts and such conveyances which are, referring to the earlier words in section 62(2), contracts and conveyances entered into before the passing of the Act.
My Lord, yes.
And section 62(2) says nothing about a conveyance after the Act made in implementation of a contract made before the Act. And for that, we have to look to section 62(1).
My Lord, that's our position.
Yes.
Entirely. And the words, and these words, and the particular word was picked up also by the Court of Appeal, is the word is obtained, past tense, not obtains, nor does it say that a contract in respect of which there might be a conveyance after the Act came into force. If it was truly Parliament's intention, then you would have expected to have seen that written into subparagraph 2. It isn't there.
You could conceive of a contract in which a purchaser did obtain title, but there was later some conveyance. Obtained title before the Act, but later there was some conveyance for some reason or other. I mean, it is possible. But speaking for myself, I find it easier to look into, ask myself, what transactions is Section 62 protecting? And because this is an act of the legislature, it's necessary to find meaning for Section 62(2). You can't just say, well, it's there, it has no additional effect because that was already outside the Act because it happened before the Act. We have to work on the basis that Parliament and the legislature intended this to have an operative effect.
Yes.
So we have to find some meaning for the words,
well,
some operation for them.
Yes. The operational meaning is this. Parliament, and I'll come to the detail of it shortly, Parliament would have been aware, because they were aware of the Oceania case and such matters, would have been aware that developers were dividing up land into lots, not getting subdivision approval, and leaving purchasers in a very difficult position. So, firstly, they wanted to make sure that from the date the Act came into effect, every single conveyance would have to have subdivision approval, or it would be null and void.
Were they trying to pin the liability for not observing the law onto the vendor, the developer, and seeing that the position of the purchaser was not that not such that they had to accept the property and take the risk of getting the subdivision approval?
My lady, we can perhaps start at this particular place, which is, it is highly unlikely, and I think the words that the Court of Appeal might have used would be absurd, to suggest that Parliament would go out of its way to try and help people who had not only done that which was prohibited, but also committed a criminal offence.
Can we just, accepting that, look at the purchaser's position and ask how the meat of this subsection works? It's clear, isn't it, that it works where there has either been a pre-act conveyance or a pre-act agreement to convey, in either case without a prior obtaining of the requisite permission. And I think it's pretty clear how it works if there's been a pre-act conveyance. One, the conveyance is not null and void, and two, someone who claims title under that conveyance or can't have the title challenged on the ground that prior to the conveyance there wasn't planning permission. That seems, it's hard to see any ambiguity at all in that part of the meat of it. But what is the practically effective part of what was intended also to be some meat, where there's only been a pre-act contract? There are two limbs. I suppose it's clear enough that the pre-act contract is not null and void, but if it can't lead to a post-act conveyance, what purpose does Parliament have in its preservation? And the second question is, does the words "a person who obtained title" have no application at all where there's merely been a pre-act contract, but only where there's a pre-act conveyance?
My Lord, yes. My Lord, taking those points in turn. Firstly, the point of the matter is that if there's a pre-act contract, it would still be open to the parties, that is, to the vendor, to obtain subdivision approval. And if the vendor did that, well, everyone is now happy.
Well, notwithstanding the illegality of the contract itself.
Well, notwithstanding that, when I say everyone's happy, well, they might not be if the authorities came after the vendor for the breach under the previous act.
Yes, because it's the owner that is liable under the previous act.
Indeed.
It's the vendor who commits the criminal act, yes.
My Lord, yes.
Right, I've got that part of your answer, so what's the second part? That is, does the bit that follows "who obtained title to a lot" have any application at all to contractual title, or does it only relate to a pre-act conveyance?
My Lord, in our respectful submission, it only relates to a pre-act conveyance, because it's title to property is the subheading for that section. And title to property would normally mean both the legal and equitable interest in the fee simple property. There is nothing to suggest here that what Parliament had in mind was simply the acquisition of a equitable title or equitable interests arising, because if there wasn't a conveyance, then of course the purchaser would be in a position where on our construction, our interpretation and interpretation of the Court of Appeal, where the vendor would be obliged to obtain, if it wanted to go through with the contract, would be obliged to obtain subdivision approval. So that would remedy that situation. It's only where title has actually been acquired, as in Oceania, that Parliament then is looking at a situation where that individual or the purchaser shouldn't be prejudiced. So if the matter comes to court, and it depends what a particular purchaser might want, because if they took the view that the property was particularly valuable, they might want to keep the title, whereas the previous owner might not want to do that, as were the facts in Oceania. But it might also be the opposite. It might be that the costs of trying to get subdivision approval, which could run into millions in something like this, would make any person who was looking to purchase the property wary of it and not want to go ahead. And so the matter then would end up in court, and it'd be a matter for the court on the facts of the particular case to decide whether a decree for specific performance ought to be issued or resisted.
And then you've got to find meaning for the earlier expression, such agreement to convey shall not be null and void due to the failure to obtain approval under subparagraph A or B. So if that would have this effect on it if the vendor sued in an action for damages and claimed that the price had gone down, wanted damages for a non-performance of the contract, that the vendor could not be met with the defence that there was a failure to obtain approval.
I beg your lady's pardon.
Well, it says the agreement to convey shall not be null and void due to the failure to obtain the approval.
Yes.
Now, as you've explained, the purchaser may say, perhaps I wasn't clear, I do apologise. The purchaser may say, well, I'm very sorry, I don't want to complete now because it'll be too expensive for us to get the subdivision approval. But the statute is saying the agreement to convey shall not be null and void due to the failure to obtain the approval.
Yes.
So that you could, if you were the vendor, at least get a claim for damages for non-performance on your...
Well, we would submit you wouldn't be successful. Because you get back to, there's a distinction between whether a contract is null and void, and secondly, whether a vendor can comply with the terms of the contract and give good title. So in circumstances like this, yes, the agreement is not null and void, but then there's a question about performance of contractual terms. And if you cannot give title which is clear of all encumbrances or even the potential of being caught up in legal action and other matters, then you would not be able to succeed in an application for specific performance.
Does one have to go as far as saying, well, it's all a matter of whether or not the prohibition is an encumbrance? The fact is, the conveyance, whatever it is null and void. Yes. Under subsection 1. So the vendor, if he sues for damages for non-payment by the purchaser, is met with the answer, well, you are not allowed to give me a conveyance at all.
Unless you get subdivision approval.
Unless you get well, yes. The conveyance itself is null and void.
Yes.
And I'm not sure if we need to go into any question about whether or not there is, you categorise this as an encumbrance or a qualification of title. You can't do it. That's what the purchaser says to the vendor. You're not allowed to give me a title.
Subsection 1.
It would operate as the famous blank sheet of paper.
Yes. Indeed.
Mr. Wilson, can I just check? I mean, this is me playing catch up, and I apologise that I've understood your submission about the meaning of the words in the last part of section 62.2, beginning any person who obtained a title to a lot and so on. As I understood what you said, but I do want to check this. you say that the word title there means full title.
Indeed.
It's not, it doesn't include mere equitable title, however one might describe that. And what it is doing on that interpretation, where it says that a person who obtains a title to a lot, that is, in effect, someone in the position of the purchasers in the Oceania case, who, of course, have got a good title under the previous act, so they don't need this act to convey, to give them good title. They've got it already. But what it is doing, as I understand you to be saying, is that it, by saying that they shall not be prejudiced by the failure to obtain the necessary approval previously, that they are enabled themselves to give good title, even without approval, in an onward conveyance, if they want to sell the property without approval. Is that what you were saying?
Well, that may well be the position, but these are all matters of facts and degrees, and depending upon the facts of a particular case. But the words are broad there, shall not be prejudiced, and one would have to look at a particular case to see whether prejudice or not would arise.
Sure. The only reason that I'm asking you for clarification about this is because of the Oceania case, one doesn't need section 62.2 for confirmation that the purchaser, prior to the commencement of this act, has obtained good title if a conveyance has actually taken place. Oceania tells us that.
Well, my lord, at this point, we need to bear in mind the timeline of the Act and Oceania, at least by the time it reached the Privy Council.
Right.
So this, in 2008, I believe, at first instance, the Oceania case went to the Supreme Court. And at first instance, the learned justice held that it was invalid, it was null and void because it was unlawful under the
conveyance itself.
The conveyance itself, that's right. It went to the Court of Appeal, and this act, of course, was enacted in 2010. It entered into effect on the 1st of January 2011, and for Great Exuma, one of the family islands, on the 1st of December 2011. A few months after the Parliament had enacted the new Act, the matter went before the Court of Appeal, who reversed the first instance decision.
I see.
So at the time, Parliament in 2009
was responding to the first instance judgment.
That's right, and saying we want to make the position clear going forwards. It didn't have the benefit of
that's
the
very helpful.
Oceania case.
So in a sense, going back to what I was asking you, I suppose you can say two things. One is a person who obtained title to a lot shall not be prejudiced. Point one is an intention to reverse the effect of the Supreme Court judgment. Of course, we know later that was done within the court system, but Parliament didn't know that at the time.
Indeed, my lord.
And is the second point that I was putting, which was the point I was putting to you before, also true, that shall not be prejudiced means that if you're a purchaser that obtained title in breach of the prohibition under the old Act, the intention is you both get good title and you yourself are able to sell on that title even without the relevant approvals.
My lord, that may well be the effect, but I'm cautious about saying it is.
Your case doesn't depend on that.
Indeed.
Yeah, I mean, but you're absolutely right, because the Act in question was enacted on the 16th of March 2010.
My lord,
the Court of Appeal decision was the 27th of July of the same year. So it was clearly a response. It was prepared as a response to the first instance judgment.
Yes, indeed.
Yes, it's not so much is it that you can then sell on without getting planning permission, because that itself would be prohibited, as I understand it. But you can resist someone challenging your title on the ground that you didn't get title from your originating conveyance.
Indeed.
Yes.
And it no doubt be a matter for contractual negotiation as to whether or not the new third-party purchaser would buy the property without subdivision approval and decide that it's worth doing that and paying for it themselves, depending, of course, on what the land is.
So
or
he can go off and get planning permission.
Yes.
And his buyer, and then sell the land, and his buyer can't say, aha, but you got it too late because the conveyance under which you purchased was null and void.
Indeed.
Yeah.
Well, could I just come back to my point for a moment? Perhaps I've got this wrong, but there's no statutory obligation on the vendor, as opposed to the purchaser, to obtain the subdivision approval. It could be either of them.
My lady, the obligation squarely, and it goes back over 50 years under the old Act and under now the new Act. The obligation is placed squarely on the vendor to obtain permission.
Well, in section 49(1), it's put into the negative tense, and it is, no lot shall be sold without the approval. And in 62(1), it's also not clear that it's the developer who's got to get the approval.
Well, my lady, the words, no land shall be sold, not no land shall be bought.
Yeah.
And so that's looking at the seller.
Yes, it is the equivalent of section 5, no owner shall sell.
Yes.
Which is rather clearer.
He could say, of course I realise that if the land is sold without permission, I may be committing a criminal offence, and I can see why Parliament would want to say that the criminal responsibility rests with the developer, not the purchaser. But could the parties not, as a matter of contract law, still agree under their contract that the responsibility belongs to one party and not the other?
Well, parties can agree anything by private bargain, but it wouldn't shift the statutory responsibility.
No, but that's a separate thing. I was thinking only of the contract, because when we look at those words, an agreement to convey shall not be null and void due to the failure to obtain the approval, we're looking only at the contract at that point.
Sorry, did you say section 49?
No, sorry, it's 62(2). Pardon me. It's trying to find a meaning that Parliament could have intended for the words, such agreement to convey shall not be null and void due to the failure to obtain the approval. Because, as I put to you, the legislature doesn't enact things in vain.
Well, in 2, we can see that the burden of the provision is put on the beneficial owner of a lot.
Well, but that could
so it doesn't say that the purchaser.
No, but it
so the burden is throughout on the beneficial owner, and that is the position with section 49. That is the position, if one reads section 61, which is that any person who contravenes the provisions of Part 5 of this Act, and Part 5 includes section 49. The obligation is on the vendor. It's not possible for the buyer to contravene the Act because there's no statutory obligation on the buyer to make sure that there is subdivision approval in place.
True, but we're having to distinguish the statutory obligations from the contractual ones. The developer may say, I want you to get the planning approvals. Of course, I realise that if you don't get them, I can't go through with this because it would be criminal, or whatever he wants to say, or he may say, I will then take a contractual right to intervene if you don't do it. But there's no reason that at some point the parties could not have agreed that someone else other than the seller will will undertake a contractual obligation to get the consent.
I wonder about that, because the Section 49(1) prohibition is that you're not allowed to agree to sell.
Yes.
So the only way an obligation could be imposed on the purchaser is once you've entered into the contract and the contract itself is prohibited. Therefore, the obligation is on the vendor to do something before he enters into a contract.
Yes.
But he could make it a precondition of his agreement to convey.
Well, that would be private bargain.
Indeed.
And as it is said, with one of the interpretative presumptions or principles, that private bargain cannot house public policy or the public duty. So,
of course, but then there's the other significance of a private bargain, which is that the Act will not, must be presumed not to take away private contractual rights.
well,
unless it's expressed, obviously.
yeah, but lady, I wonder whether that proposition is correct, because what Parliament is doing with this new Act, as we can see from Section 3, where it sets out the objects, and it may be worth just looking at that. Section 3, I believe it's page MS 1136. And if we go to page 1141. And the objects and purposes of this Act are to provide for a land use planning-based development control system led by policy, land and use designations and zoning, prevent indiscriminate division and development of land. Well, that's something with which we're very much concerned with in this case. Ensure, ensure the efficient and orderly provision of infrastructure and services to the built environment, promote sustainable development in a healthy natural environment, maintain and improve the quality of the physical and natural environment, protect and conserve the natural and cultural heritage of the Bahamas, provide for planning processes that are fair by making them open, accessible, timely, and efficient. And just pausing there, planning processes so that adjacent owners, members of the public, government departments, other businesses, people who may have a say in all of this. And this is one of the key objects and purposes. H, recognise the decision-making authority and accountability of the government in land use planning, and plan for the development and maintenance of safe and viable communities within the policies and by the means provided under this Act. Section 62 contains a policy and sets out the means and provides under the Act what is to happen with regard to conveyances going forward. So parties, if they wish to enter into private bargaining, they can, but it doesn't oust the prohibition or the consequences in criminal law for breach by the vendor.
Yes, but it touches on the remedies for the private contract, doesn't it? The parties may wish to know what their remedies are, and if a statute must be presumed not to take away contractual rights, then the section will not intervene and interfere with a contract, except so far as is specifically stated in the statute. So there may be provisions in there. I mean, the parties could have agreed that they would give instructions to a named person to get the approvals or something like that, and it's not been obtained. And then they may have allocated the responsibility and liability for that and so on. And it may be that they want to enforce remedies for failures. It has nothing to do with the planning processes, how they organise their private ordering.
I wonder, I mean, any such arrangement would have to be pre the contract of sale, because the contract of sale itself is and was under the prior law a criminal arrangement as far as the vendor was concerned. Yes. And the presumption that one doesn't interfere with contractual rights has to be assessed in the context of this circumstance, that the normal contract, unless there is some collateral contract, is a criminal act.
Yes.
But I wonder if we should better allow you to develop your submissions as time is ticking on.
Can I just make one observation? As I understand it, the interrelationship between the statutory obligation on the vendor and the contractual obligation could surely be dealt with by an implied term. Isn't there an implied term in the contract that the vendor shall obtain the necessary permissions? And there's no evidence that there's any been contracting round that in this case, is there?
Well, my lord, yes. In circumstances where a vendor is under a statutory obligation to obtain subdivision approval or approval from the minister on matters as basic as utilities, it is, we would submit, an implied term in the contract. Certainly it can be constructed that this way, that they would have obtained it or will be in the process of obtaining it, because it strikes at the very heart of the bargain that the parties are entering into. If you purchase a lot on the assumption that you will have the infrastructure there, it's a very different bargain if then you end up having to do that yourself, or would end up having to do that yourself and pay hundreds of thousands or millions of US dollars.
Thank you.
You might put it higher and say it's an implied warranty that it has already been obtained, mightn't you?
Yes.
Because that's what the criminal law required to happen before the contract was entered into.
Indeed, and my lord, one might say it's a material non-disclosure, which could affect the validity of the contract. So not void ab initio, but perhaps can be rescinded on the basis of a material non-disclosure.
Can I just ask you one other question? I am conscious of the time. Section 62.2 in the first line refers to things done by a beneficial owner of a lot in a subdivision, and inter alia, agreeing to convey without getting planning permission. I suppose that would include a sub-vendor who has got the benefit of a contract to sell to him, but not yet completion.
Yes.
Does that shed any light on the meaning of the words "who obtain title" 3 lines up from the end of the subsection 2? You know, what I'm really saying is beneficial owner is clearly not just talking about legal title.
So one could have a situation where beneficial owner, what is postulated here, conveyed or agreed to convey land and didn't have the necessary approvals.
Yeah. I'm simply asking whether it's a pointer to interpreting "who obtained title" as not merely confined to legal title. I mean, you may say it points exactly the other way, but I'm just really looking for an exploration about the implications of the use of beneficial owner at that stage in the subsection.
So the no prejudice clause at the end of that subsection refers to the failure of the owner of the subdivision.
That presumably means it could be legal or beneficial owner of the subdivision.
I mean, the focus is still on whether title was obtained by the purchaser.
Yes.
Yes. So there is that distinction about the obtaining of title to a lot. And if Parliament had intended to say obtain title, and that was to refer to title was to refer to legal or equitable title, then that is something which one would expect it to have said. I mean, it said elsewhere beneficial owner. It said elsewhere owner of the subdivision. But in relation to the purchaser, it talks about who obtained title to a lot.
Just a footnote, there is a statutory definition of owner, 1145.
So, yes, owner in relation to any land means a person other than a mortgagee, not in possession, who, whether in his own right or as trustee or agent for any other person, has the freehold or the legal right to possession of the land. So that's talking about legal rights, and is entitled to receive the economic rent of the land, or where the land is not let at an economic rent, would be so entitled if it were so let, and includes a person who is an owner with another person as joint tenant or tenant in common of a freehold estate.
Thank you.
So that does look like legal title that they're talking about.
It does.
Yeah.
As I understand it, anyway, on section 62, you say, look at the heading of that provision, which refers to title, and then clearly the key operative provision is section 62(1), which is talking about a conveyance. So
Indeed. And
that tends to indicate that title is used in that provision is indeed looking at what you get when you have a conveyance, i.e. legal title.
My Lord, yes.
Yeah.
Which, of course, was the position that would have been in Parliament's mind in relation to the Oceania case, which it was at first instance at that time, and that decision was there, and they would have known it was pending in the Court of Appeal as well.
Yes, thank you.
So, my Lord, I'm conscious of the time, and
Well, given there was an interruption, I think the fair thing to do is to split the inconvenience of the interruption between the parties. So if I were to give you till 22, that gives you another 10 minutes, and it takes 10 minutes off the appellant's case. But I think that would fairly allocate the disruption.
my Lord, I'm most grateful. And
I just confirm, Ms. Hepburn, would that be convenient or acceptable to you, giving you a 20-minute reply period? Thank you very much.
Yes, Malik.
Thank you.
so, my Lords, to put the time that's left to me to its best use, can I approach it in two ways? Firstly, there are a few points that I would wish to make further, but I would also be assisted by any further points that your lordships wish to raise, because there's a lot of material that I could go to, but I won't have time to go to it. But it may be that there's certain matters that your lordships would like to hear from me on before I resume my seat.
Well, you can be assured we will take into account everything that is said in your written case, and Ms. Hepburn, in your written case too. I'll just see if my colleagues are wanting to raise any particular points. No, just proceed as you wish.
My Lord, yes. So, my Lords, In summary, so far as the interpretative rules are concerned, we submit, and it's set out in detail in our written case, that the Court of Appeal had regard firstly to the plain meaning rule and could not find any other meaning other than the one that 62(1) makes it clear that any means any with regards to conveyances after the Act came into force, and that's plain and straightforward. But the Court of Appeal, to its credit, didn't stop there simply. It considered the purposive rule. It had regards to Section 3. It considered the mischief of developers and others not obtaining subdivision approval and putting out these lots, and the impact that it had on the people and communities, land and environment of the Bahamas. They also considered the golden rule that a court should interpret a provision on the basis that Parliament did not intend an absurdity, and the suggestion that someone who comes to the court having committed criminal offences, at the very least having breached the law, entered into prohibited actions, is someone who Parliament would be looking to protect in subsection 2. And taking all those matters into account, the Court of Appeal found themselves driven to the ineluctable conclusion that Section 62 meant that subdivision approval for any conveyance after the date that the Act came into effect had to be obtained, or it would be rendered null and void. And your Lordships may have had the opportunity of reading some of the exchanges in the Court of Appeal between my learned friend and the Justices of Appeal. But they gave pretty short shrift to the suggestion that this was something that this sort of conduct was something which the Parliament was prepared to look upon as being okay to continue, and that there was a line in the sand drawn, and from this day forwards, to put it in the language of the Court of Appeal, from that day forwards, when it came into effect, any conveyance would have to comply with Section 49, or it would be rendered null and void. And so, taking all those matters into account, we submit that the Court of Appeal, and no court properly directing itself and applying the interpretive principles and rules, could have reached any other decision. And once it reached that decision, then it is under a duty, because the duty of the court is to ascertain the intention of Parliament. It's to interpret the law, not make it. A number of arguments by my learned friend goes to, there should have been another outcome, whether to some extent it's a private or personal situation of gain for the appellant that one is looking at. But what the court had to do wasn't a subjective matter, wasn't, well, this is something we want or don't want. It's what was Parliament's intention, and once that intention is ascertained, that's it. It's not like a situation where one is concerned with, say, development of the common law, where the highest courts may have to choose between two conflicting rules and the underlying policies which are involved. This is a much more rigid exercise in terms of what a court can do. Ascertain Parliament's intention, apply it to the facts of the particular case, and that is the end of the matter.
Indeed, I'm sure we're all very well aware of the responsibility of the courts in relation to acts of Parliament, but the intention of Parliament is generally to create a change in the law. And so in section 62.2, we are having to focus on what is that change in the law and see what it is. But you can, in an act of Parliament, have more than one policy. I mean, section 3 has got a long list. Just treat that as one policy for a moment, to protect the heritage and environment of the Bahamas. But it can, in some different areas of the Act, want to put in a different policy, for instance, protecting existing contracts, insofar as they deserve to be protected as they stood immediately before the Act. But that may also be a policy. So it's not just one policy, we're just trying to find the policy for this provision.
My lady, yes. And in considering any particular provision, it's the position that it is considered in the context of the Act. So one looks at the provision, and if there are other provisions there which may push one to a conclusion one way or the other, then so be it. We submit that on the question of being pushed in one direction or another, section 49 is very clear, where it maintains that no land shall be sold, should agree to be sold, demise, conveyed, and so on. We say that the policy and Parliament's approach and intention so far as breaches of the prohibition was concerned was really beefed up. So if we look at the old Act, under section 9 of the old Act, there was at most a fine of £4,000 for breach of the section 5 on summary conviction. Under the new Act, section 61, that fine rises to £60,000 and 1 year's imprisonment. That shows what Parliament felt, and the intention was to bring to an end, or at least to really try to control it, by having some really tough sanctions, any continued breaches of the prohibition against those who would choose not to obtain subdivision approval. This policy, as one can see from, and your lordships may have had an opportunity of looking at the speech by the Honourable Prime Minister in full, this is a matter of tremendous national importance. And that can be seen by the fact that in 2010, not only did Parliament make it explicitly clear now, not simply that it's prohibited, not simply that it's a criminal offence, but from the commercial point of view, it will be null and void if you don't get subdivision approval. And then on top of that, they massively increased the sanctions for any breach of that Act. And so we submit that underscores the direction in which Parliament wanted to take the country, and that in those circumstances there can be no, we submit, truly rational criticism of the decision reached by the Court of Appeal. Now, with regards to the specific ground, so we say, first of all, your lordships, with respect, should look at what the Court of Appeal did. Did they apply proper interpretative rules, principles, and presumptions to arrive at their conclusion? We say they did so impeccably in a concise judgment. Then the next matter, and the matter on which I'd like to round up on, is very briefly a whistle-stop tour, virtually, through the discrete grounds which have been submitted by my learned friend. So we say, first of all, looking at what the Court of Appeal did, there's no error of law, and that is, or ought to be, the end of the matter. With regards to the specific criticisms, it is said that the Court of Appeal erred by not taking into consideration the overall principles of a repealed act as provided by Section 20C of the Interpretation Act. We submit that Section 20C of the Interpretation Act provides no support whatsoever, because if we go to its page 1116, Um, 20C says that, well, where a written law, and those are the important words to underline, repeals in whole or in part any other written law, the repeal shall not, and it's 20C that's relied upon by the appellant, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any written law so repealed. Well,
the short point is protecting a prior statutory right.
Which is not the position here. There's no statutory right to convey or agree to convey property without subdivision approval. And under the old Act, the Minister, and under the new Act, the Town Planning Committee. So that point goes nowhere. Then the second criticism under the first ground is that the Court of Appeal ought to have found that since Section 62.2 preserved the validity of the agreement for sale and the rights of the parties thereto, the intent of the savings clause was to ensure that any conveyance made pursuant to such agreement would also be preserved. This second argument in our submission is a non sequitur. It simply does not necessarily follow that the mere provision that an agreement to convey a lot would not be null and void must also mean that any subsequent conveyance made after the Act comes into force must be valid. It simply doesn't follow. Especially where Parliament has expressly provided that any conveyance after the Act comes into force shall be null and void if prior subdivision approval has not been obtained. What the saving of the validity of an agreement to convey a lot does is provide the owner of the lot with an opportunity to make a lawful conveyance, where the conveyance takes place after the Act comes into effect. And the Court of Appeal said, well, there's absolutely nothing irrational or wrong about that, because you're giving people an opportunity to comply with the law. And that is what Section 62.2 does. It gives an opportunity for compliance with the law for someone, the beneficial owner of a lot, who has previously acted in contravention of the law and also committed a criminal offence. In order to make a lawful conveyance, all the owner has to do is to obtain subdivision approval. Yeah. I say all, but it may be that for some who are unscrupulous, they don't wish to spend the money that would be involved in obtaining subdivision approval. Right. Yes, I see that my time
Yes, I think I'm going to have to direct the whistle-stop tour to the terminus.
My lord, yes. Well,
if there's anything you want to say, it will have to be within a minute.
yes. Well, my lord, in essence this, and we come back to where we started, essentially. Two questions of interpretation with regards to section 62.1, which is plain, and section 62.2, which does not qualify, limit, or reduce the scope of section 62.1. We come back to the third point that we made in opening, that this is about also, from a contractual point of view, good title. And on any view, even if the appellant was right on all the other arguments, it would be wrong on this, because they would not be entitled, or the appellant would not be entitled to a decree for specific performance, and in those circumstances, on a separate, discrete ground, the criticism of the order that the Court of Appeal made does not stand up to serious inspection.
Do we have the authorities on the question of what's necessary constitutes good title for the purposes of the law of the Bahamas?
My ladies, I understand the position.
The same as in the UK?
Indeed. And your ladyship would have seen, for instance, with regards to questions of interpretive principles and the rest of it, we cited a number of Bahamian authorities. And on these matters, certainly no one has suggested on either side in this case that it is not consistent with the English common law on these matters. Of course, statutory provisions be a different matter.
Subject to your Quieting of Titles Act, you mean pre-registration English common law?
Yes, pre-registration.
Yeah.
And just an add-on to that, I'm sorry. Just an add-on, do you have any provision for damages in lieu of specific performance?
Is your lady asking a question about the law generally, or in this
Yes.
particular case?
Well, so in this case, I wanted just to consider what remedies were available.
Yes, damages was an alternative. So it was the prayer for relief was damages for breach of contract, alternatively return of the monies.
We have a special act dealing with something called damages in lieu of specific performance.
Yes, indeed.
But that's not available, or no parallel in...
Might I just speak to my learned junior, who is Bahamian and practices at Bahamian Bar? I'm told, indeed, I'm instructed that you can obtain damages in lieu, not under an act, but as part of the development of the common law.
Well, I wonder if it would be helpful if a very short note on that could be agreed between you and Ms. Hepburn and submitted to us within 7 days, just to set out what the position is there. Would that be acceptable?
Yes, absolutely.
Thank you. Yes.
My lord, yes.
Mr. Wilson, thank you very much. Ms. Hepburn.
Yes, actually, my lord. My lord, the first thing that I would wish to draw our reply to, and once again, my lords, we are going back to highlight to the court that our position is that section 62, subsection 2, does not diminish or invalidate the clause under section 62, subsection 1. Our position is merely that it qualifies it, my lord. And what the court must put into its mind is what was Parliament's intention in including that word, notwithstanding, in section 62, subsection 2. And my lords, it is essential that this consideration be put into effect, because what we are predominantly saying is that with those words, Parliament's intent of qualifying section 62, subsection 2, subsection 1, was that the conveyance will be valid as long as it flows from an agreement to convey that predates the prior coming into effect of this act, my lord. My Lord, this is pivotal because I know there was references made to no mention of conveyances coming into effect after the act. That section 62.2 doesn't state or expressly set out that they refer to a conveyance. But respectfully, my Lord, an agreement to convey, the sole purpose of preserving an agreement to convey, the only outcome of an agreement to convey is a conveyance. And so, my Lord, I don't know if there was a requirement to expressly state that conveyances after the act come into effect. Because by preserving that agreement to convey, there is only one possible outcome of an agreement to convey. There's no other purpose of having a valid agreement if not to have a conveyance. And so our position is that there was no requirement to specifically state conveyances after the act. My lords, there was also a point in which, and this would have actually been the court, which brought up attention to a breach of clause 5.13. However, this brings us back to another point in the writ of summons, my lord. The actual claim in the Supreme Court. Firstly, my lord, I wish to point out that there is no claim for damages in the plaintiff's claim. In fact, as we indicated to the court before, the plaintiff had, in the case therein, and the respondent obviously in this case, my lord, they had already inferred their interpretation of section 62. And so their claim in its entirety was for the return of the sums of money. My lord, the reason that I think that this is pertinent is because in the actual statement of claim, it doesn't actually set out in particular the player breaches, my lord. I note at paragraph 12, it went on to state that.
Could you give us the page number of the statement of claim, please?
Pardon me, my lord?
Could you give us the page number of the statement of claim from which you're reading?
Oh, yes, certainly, my lord. This would be, 1 second, my lord. If my lords may go to page MS7.
Thank you.
My lords, I would have referred you in the first instance to the actual claim of the respondent, and that's found at MS11. It was for the sum with interest thereon, all necessary and consequential accounts, directions, and inquiries, interest for the relief and cost. And my lord, I went back up, my lord, because if you would note in this particular writ and in the statement of claim, there's no particulars of breach that's been placed inside of this particular writ, my lord. I note at paragraph 12, the respondent asserts that in breach of the said agreement and notwithstanding the aforementioned request made by the attorneys, the plaintiff on his behalf, the defendant wrongfully failed and refused and continues to neglect and refuse to provide the plaintiff with approval from the minister as is required by section 62 of the said act. But again, my lords, I say, we are here before you today to provide us with the correct interpretation of section 62 of the said act. So how can it be that we have a claim, which was the respondent's claim, and that is what we also, my lord, put forward, the court has to draw its mind to. The respondent's claim was that the breach of the agreement was that the appellant, the appellant herein was not in compliance with section 62. And as a result of that, they are entitled to their monies back. Our position is that that cannot be a rational conclusion, because once the court determines whether or not subdivision approval is required, that does not invalidate the agreement. And so we humbly submit that there still is no breach of the agreement, because as indicated, the valid agreement still exists.
But
and my lord,
I'm sorry, could I just quickly ask you, that does it follow from that that the reason why the statute is silent about what happens to the agreement made pre-act, and doesn't actually say specifically, and any conveyance pursuant to that agreement, is because it's leaving the agreement in being in full force and effect, and leaving it to the parties to find a way of making it capable of lawful performance, and if not, unscrambling it?
Well, I apologize, my lady. It is our humble submission that it cannot be read to take that into consideration. My lady, we would have drew to the court's attention that the act, which has been occurring for over 4 decades by persons, this was something that the Parliament was well aware of, which was occurring. In fact, the Parliament, which is made up of the respective MPs, they came out and said, you know what, we as the government are also guilty of committing this crime. And so, milady, it is my position that in staying silent, the intention was certainly not for the government or developers or vendors to now go out and satisfy a criteria that vendors were never subject to previously. And so we would once again wish to draw to the court's attention that the extensive criteria that is now required under the Planning and Subdivision Act was certainly not a criteria in the Private Roads and Subdivision Act. And, my lord, in speaking to the Private Roads and Subdivision Act, I wish to once again state that there was a position that an encumbrance exists as a result of there being a breach. However, my lord, we would humbly ask that you reject that claim, because as noted in the case of Oceana, there was a breach that existed. Those 11 conveyances which existed was in breach of the vendor not receiving subdivision approval. The court ruled those conveyances are still valid. And so if a breach of not having a subdivision approval is considered an encumbrance, how is it that a court is able to make an order that a conveyance is still valid? A conveyance can never be valid with an encumbrance existing. But the court in Oceana made their ruling that despite this particular vendor not receiving subdivision approval, they still had good title. However, they were in breach of a criminal offense.
Your position, as I understand it, Ms. Hepburn, is that your clients are entitled to demand that the respondent take the conveyance of the property from you without your clients having obtained the necessary approvals under the 2010 Act. Is that right?
Yes, my lord.
Yes, thank you.
Yes, my lord. And my lord, there is a point further in which my learned friend asserted that section 62.2 only relates to legal title. And my lords, it is my humble submission that the wording alone of section 62.2 contradicts that. In fact, the beginning of 62.2 states, notwithstanding subsection 1, where the beneficial owner, my lords. And that is important because it is clear that Parliament had already put to its mind that there are 2 types of owners. And I would have referred the court earlier to legislation from the 80s, in which when Parliament wishes to make a distinction between legal and equitable interests in a property, they do so, and they do so in legislation. However, in this particular case, my lords, there is no distinction between the type of title that would be protected. And this is why they make reference to beneficial owner as well, because Mr. Momin, as a beneficial owner who obtained equitable title, will not be prejudiced by receiving this conveyance. And it is notwithstanding the provision of section 62.1. In no way is section 62.1 diminished. It's just that it is conjoined with section 62.2. And so, my lords, we also noted that there was a reference, my lord, the point is, if it's a pre-act contract, then it would still be open to get the subdivision approval, my lords. And respectfully, we note that this was not the intention of Parliament. It is clear that the same protection, because what I would like to point out to the court, my lords, is that despite what is being noted in section 62, subsection 1, if we accept the respondent's arguments as it stands, what they are doing is predominantly locking in all previous purchasers to never being able to sell their land again. And my lords, the reason that I'm saying that is because the same protection that section 62, subsection 1 is protecting a previous purchaser, the current respondent would have that same form of protection. Their rights should be grandfathered in based on the clauses which has been presented in section 62, subsection 2. My lords, it cannot be that there's any particular bias or favoritism from one side, because as indicated, this agreement to convey was entered into from 2008.
Could I just ask you this swiftly? Could it not be said the policy of the Act was to ensure all subdivision approvals were obtained? Secondly, to draw a fair balance between developers and purchasers in this situation. And it did so by preserving the validity, or creating even the validity, of the agreement to convey, and giving you the opportunity, or your clients the opportunity, to reach some way of going forward. But if the line was drawn that henceforward all developments should have subdivision approval, then it would engage the responsibility of the developer as well as that of the purchaser.
Well, milady, firstly, I would like to say that I am cautious of using the word developer. And the reason that I am cautious of that is because the section 62 specifically does not refer to just developers. In this particular instance, my client is February Point Resort Estates Limited. But there are instances, and this is why I would have referred the court to the Prime Minister admitting it as well. The government has been guilty of it. Any family member who had large acres of land and attempted to divide more than 4 lots of land was guilty of subdividing and had to be subject to this subdivision approval. And so it's not solely in this normal circumstance, this is the case that is before the court. But similarly, it could have been a father and a daughter who had entered into an agreement for sale, who owned 20 acres of land and wanted to sell off a piece of lot to his daughter.
Yeah, so you prefer vendor to be used rather than developer, yeah?
Pardon me, my lord?
You prefer the owner or vendor to be used rather than developer?
Yes, my lord, yes. because in our view, the section 62 does not specifically take developer in the sense that you must develop this subdivision in a certain standard. It's pertaining to vendors, beneficial owners, purchasers, whether that be the government, whether that be a developer, whether that be a father or a grandfather or an uncle. It's those persons who own land and wish to sell their acreage of land into more than 4 lots, my lord.
Thank you.
And I just wish to point out to the court as well, because an image was being portrayed that that the developer, in some ways, I believe the exact wording of my learned friend was that there's nothing to say that they got subdivision approvals for the other lots. My lords, I just wish to point out that the other lots is not currently before the court, and so certainly we would not have proffered evidence pertaining to other lots. However, which we would like to point out is in the actual agreement for sale, my lords, you would note that, and if I can take you quickly to it just for cross-reference, but in the actual agreement for sale, provisions are made where Mr. Momin, as well as all of the other occupants in February Point, has to make maintenance payments every quarter, I believe that is, and I'll just take you to the agreement for sale, and that would be found at 505 for future record purposes, MS 505. But under clause 3.11.2, the purchaser agreed in advance to an annual maintenance charge to the vendor, representing the purchaser's pro rata share of the expenses budgeted by the vendor for the upkeep, maintenance, and management of the common areas, roads, paths, and walkways of the resort development, and all other equipment pertaining thereto, and all such other reasonable expenses, including insurance, as the vendor shall reasonably incur in connection with the resort community. So in advance, Mr. Momin had already agreed to pay maintenance charges in future to upkeep roads, to upkeep the common areas, to upkeep pathways. This was a payment, that was an agreement that was already made and signed from 2008. And if my lords would look at the private roads and subdivisions, the focus is predominantly not on the preservation of wetlands and forestry, but to ensure that roads as well as utilities are upkept and available to those persons. And clearly, February Point Resort Estates Limited made provisions for that. And so it's not as if our client in some ways was backhanded or attempting to throw some property on the respondent that no provisions were made for.
No, but it's not being suggested that the purchaser was in breach of 311.2. If you submitted maintenance charges to him, presumably they were paid. There's no suggestion that he has breached the contract in any way.
No, my lords. No. My point was not that there was a breach of. My point was not that there was a breach of maintenance charges. My point is that the appellant has made provisions to ensure that the purchaser at the time, and the purchaser being Mr. Momin, at the time of entering this agreement, had provisions for the upkeep and maintenance and management of roads and pathways and walkways for access to his property. And if you will note the wording of the Private Roads and Subdivision Act, it was focused on the roads and access and pathways.
Yes, but it was the maintenance charges paid to the vendor for the expenses incurred by the vendor. So it was the vendor who was responsible for these things.
Well, it would be the purchaser who would be making those payments in advance.
Because the vendor had done the necessary maintenance and upkeep and management of those areas and put in the roads, etc.
Yes, my lord.
Yes. Okay. You better bring your submissions to a close now because we're running out of time.
I'm much obliged, my lord. My lord, so on that basis, we would only say that based on the wordings found in subsection 62, subsection 2, the appellant is in a position to force, my lord, was the wording used. However, our wording would be that he is in a position to convey this particular subject lot to the respondent without the subdivision approval. And this approval is based on the wording of section 62, subsection 2, preserving the validity of the agreement to convey. My lords, we just wish once again reiterate that the sole purpose of the legislature preserving that agreement would be to allow for any conveyance executed after, notwithstanding subsection 62(1), to not be prejudiced.
Thank you.
And my lords, that would be the submissions of the reply of the appellant, that the protection of the purchaser receiving that conveyance would also be, my lord, ingrained in section 62 too.
Thank you very much.
My lord, I wonder if I might just mention the question of damages,
yes,
by way of clarification.
Very briefly.
Very briefly, page 11, which I believe my learned friend took you to.
Is the short point that it's in the pleading but not the prayer?
Indeed.
Yes, I had noted.
Particularly as a special damage, I must say I read that as a claim for damages.
Well, it just didn't get followed up in the prayer, but I don't think anybody's going to hold that against you.
And then in paragraph 2 of the prayer, there is the account directions and inquiries.
Yeah, yeah.
as a discrete prayer.
Thank you very much.
My Lord. Thank you.
Well, I should like to thank Council for their submissions in this interesting case and important case in the context of the issues which have arisen in the Bahamas. And I'd also like to thank those who have assisted Council in the preparation of the papers and their submissions. I should wish to add today that this is the last case in which Lady Arden will be sitting in the Judicial Committee of the Privy Council, because she is due to retire very shortly. And I would like to take the opportunity to thank her for her distinguished service on the board and also in the UK Supreme Court, and wish her well in what will no doubt, from her past performance, be a very active retirement. The board will now take time to consider what advice they will humbly tender to Her Majesty. We will adjourn.
I will thank the President. Thank you.